Can you hear me now?
Hey, it's Judge McBurney. I had to make sure we were up and running on the YouTube feed, and I just needed to get the documents on my screen. Good afternoon. We've got two bond hearings to cover. One is a bond hearing in State versus Warner. Mr. Katz has filed a second motion for bond. He filed one when it was a CP case and never got a hearing. It is now an SC case. So we'll need to work through that. And then we also have a bond reduction request in the case of State versus Farouk. And I am here to handle both. Have the attorneys agreed on the order in which we'll be doing this?
Nobody's talked to me about it, Judge. I don't really care. Whatever the state wants to do.
Okay.
Just
The
to warn
state's
you,
ready
Your
on.
Honor, the defendant's ex-wife is Sly Marie, who's present in this Zoom chat. There wasn't a waiting room for this chat, so just letting Your Honor know that she is in this chat.
Okay, I see it says Silmarie's iPhone. The waiting room feature went away. I sort of enjoyed being able to serve as the gatekeeper, but I guess people didn't like it and they took it away from me. So it's good to know who all is on. It sounds like we have one more person on for the Farouk matter than we do for the other. Why don't we just knock that one out first?
It is ready, Your Honor.
Great. So let's get started. You ready, Mr. Forte? All right. This is indictment 19 SC 173668. And as I said, it's State versus Farouk, F-A-R-U-Q. Ms. Patel is seeking a reduction in the bond. It sounds like Mr. Farouk was given a bond of $80,000 through the 10% program in February of this year. And he's still there. So that was a bond amount that at this point seems unreachable for Mr. Farouk. And there were some additional concerns that Ms. Patel raised in her petition. I'll let her give voice to those. But before we do that, Ms. Patel, your client has waived his presence. Is that correct?
Yes, Your Honor.
Okay, let me just get the docket up. 173668. Okay, and you have filed a waiver to that effect. So let's start talking. Tell me what's going on with Mr. Farouk and why you think things ought to change.
Thank you, Your Honor. Your Honor had set an $80,000 bond through the 10% program at the jail. At that bond hearing, Your Honor had indicated that if things had stalled with Mr. Farouk's case or if facts had changed, we could petition for bond modification. And so we're before this court. My client has not been able to make bond. The case itself has not had much traction given the circumstances with COVID, which are out of.
We're missing you, Ms. Patel.
I apologize, my Zoom kicked me out. But
Okay.
I'm not sure where I was cut off at.
Well, I heard that the case had not made a lot of forward progress, because that's true for most cases right now.
Sure.
Because of COVID.
And so presently, Mr. Farouk is him and his family are unable to make the cash bond. His ex-wife, who's on the call, would be, if Your Honor converted the bond to a straight bond, would be able to afford that. Alternatively, if Your Honor reduced the bond to 40,000 through the 10% program, they would be able to make that. His ex-wife lost her job, and so her savings is used to provide for her and their 2 children. And so the next issue was that not only had not much traction been made on the case, but their child, she's 20 years old. She was in the ICU at Scottish Rite up until yesterday, where she was released. With that being said, because of the extent to which she had issues, there's still a extensive recovery phase. She's on bed rest. Miss Sile Marie still has to essentially function as a nurse for her daughter. They have a 12-year-old son, and because of the daughter's compromised position, the son cannot reside in the house in the event that he contracts COVID and gives it to the daughter again. So right now, he's staying with her elderly parents. It's not an ideal situation in terms of the care for the child. They're old, and so there's also a concern that he could get them sick. They try to get him tested every week, but that's about as much as they can do with those circumstances. And so I had her in the chat just in the event that Your Honor had any questions about that. Just as a brief refresher, my client has no felony convictions. He's 42 years old. Prior to his arrest, he was working, and I believe that should he be released, he could get his job back. There were conditions on the last bond, such as an ankle monitor and a curfew, which we have no opposition to. We were just asking for either the bond to become a straight bond or that the cash bond part be reduced.
Okay. I'm not seeing the ankle monitor or curfew as a condition of the bond. The bond order that I signed in February had unsurprisingly, no contact with the victim and stay away from an address on Fulton Industrial. And then there's a curfew, but not an ankle monitor.
Oh, okay.
So a curfew, but basically a nighttime curfew. You're at home from 8 p.m. to 7 a.m. Remind me what kind of work Mr. Farouk did before.
So he was a shipping supervisor at CDI, and he was a full-time employee there.
And it's your understanding that he could return there?
Either that he could return there or that that he would be able to work. He hasn't really had an issue in terms of maintaining employment. It's just been that the longevity of being in custody on this case has made it hard for him to post his bond. And
Okay.
he has been in custody for 261 days.
Looks like he went in October of last year, something near that. Okay. So he would work maybe in the job he had before, and he would reside with his ex-wife.
His parents lived here, so he could reside with his mother. Alternatively, he could reside with his ex-wife. I believe the last time that we had the bond hearing, we had talked about him living with his family, meaning his parents.
With his parents, and that's in the metro Atlanta area?
I have the address written somewhere, but I believe so. I can
Okay.
get that.
And how would living with his parents help Ms. Silmarie with taking care of the kids?
So the 12-year-old could reside with him so that her grandparents are not burdened with having to watch him while she maintains care for the daughter.
Okay. Can I ask her about that?
Yes.
Okay.
You can unmute, ma'am.
Yes,
Hey, can you state your name for the record, just so I refer to you by the right name?
yes, Sil Marie Ortiz.
Ortiz. So you're Ms. Ortiz.
Yes,
And you were at one point married to Mr. Farouk?
Yes. For
Okay.
13 years.
And you have two children, one of whom was very, very ill and just got out of the hospital.
That's correct.
Okay, I'm glad to hear that she's doing better.
Thank
That's great news. And then you have a younger child, the 12-year-old son.
Mhm.
Okay, and that's who would stay with Mr. Farouk if he were able to make bond.
That's correct.
And that would help you because then you could focus on your daughter and your parents wouldn't need to be worrying about your son being a vector for them for COVID.
Right. That's correct.
Okay, and you were working, what kind of work were you doing?
Distribution for Flowers Bakery.
Okay, and that job went away or you had to stop to take
I
care
had
of
to
your daughter?
stop. Yeah, they won't even allow me because I've been in like close contact with my daughter, so they're not even allowing me to go in.
Okay. Are you able to collect unemployment?
I have not even honestly had a chance to even look into that.
Okay, well, and Ms. Patel mentioned that for now you are living off of savings, but ideally you'd be able to get back to work as well.
Yes,
Okay.
no, absolutely.
Can you describe, and before you answer, I'll tell you why I'm asking, the nature of your relationship right now with Mr. Farouk? And I ask only because I want to understand if you guys are on good speaking terms, and it would be a cooperative relationship in terms of getting your son taken care of, or if we would be adding an element of drama so that if he's out, meaning Mr. Farouk, and he's taking care of your son, that's going to be conflict and tension and whatnot.
No, not absolutely. We actually have had like we've been together since high school and got married for 15 years. So we do have a close relationship to this point, even me with his family. He's my son's football coach. I'm the football team mom. He's very involved in like his life and my kids' lives. So he's welcome to stay here. He has in the past. That's not an issue whatsoever. He really is a lot of support for me and the kids and the community really here.
Okay. All right. Thank you.
Thank you.
So Ms. Hodge, I'm interested in your perspective. There's already a bond, so we're not going to revisit should there be a bond or not. What is on the table now is either restructuring it so it's the same dollar amount, but it would be postable through a bonding company. My concern with that is then we lose the pretrial supervision piece, which can be helpful. Although the main thing that I'd want to ensure is that Mr. Farouk's coming to court, and in some ways bonding companies are just as good at that. But we would lose the pretrial supervision piece. The other option that has been suggested is lower the dollar amount so that it is affordable. It becomes a meaningful bond as opposed to a $1 billion bond that no one could make. But then if it were still through the sheriff's 10% program, two good things. One, whoever is able to put that money up gets most of it back in the end, regardless of the outcome of the case. Two, we would maintain the pretrial supervision piece. So I'd like your perspective on whether nothing should change or if something's going to change, what you think is the right way to do it.
My first perspective, Your Honor, is nothing should change. I think that the bond is reasonable in light of the charges, and we won't go back into that because we've already had a hearing on that, as Your Honor said. However, if the court is inclined to change, I would ask that it be some type of split bond so that we can have supervision through pretrial services and also have a component where a percentage has to be posted.
So if I kept it through the sheriff's 10% program, an amount does have to be posted. It's not that I'm in no way suggesting an option of a signature bond. That isn't what I meant. If that's what I said, it's not what's going to happen. There would be money put up either way. It sounds like there is an amount that Mr. Farouk's family has figured out they can post in these times. And that amount would be, it sounds like around $4,000, because $4,000 would get you to that $40,000 10% program. And my guess is there are bonding companies that are out there that say, look, you give me $4,000, I'll cover an $80,000 bond for you. And so I could see why from the defense perspective, they're neutral, because either one of those options, there's enough money to meet what would have to be paid. So that's what I'm wrestling with. I think my preference is through the Sheriff's 10% program, because we get the supervision and it's not money that just goes to a bonding company. There's nothing wrong with bonding companies, but this is money that could be well used by whoever puts it up when they get it back. So I think that's where I'm leaning, but what I'm hearing you say, Ms. Hodge, is don't change it. That's your first choice. And then the second would be, please structure it in a way that there's both supervision and, my phrase, not yours, skin in the game, meaning there is some money that has been put forth, so that might serve as a deterrent if Mr. Farouk was thinking, I want to leave town. Is that a fair summary?
It is, Your Honor, and we would also ask that the ankle monitor is in place as a condition of the bond.
Okay.
In addition to the curfew, no contact with the victim and stay away from the location.
Sure, none of that would change, and I'll consider the addition that you just suggested. Ms. Ortiz, one more question for you. You mentioned that you've had a very long-term relationship with Mr. Farouk. Have you all always been in the Atlanta area, or are you newer to the Atlanta area?
We've been here since 1994, both of us.
Okay,
Always.
long-term.
Yeah, this is
ties.
home. This is home. Yeah,
Okay, all right, thank you.
thank you.
So now, Ms. Hodge, you can remind me, you may have covered this in the past. Tell me where we are in terms of this case being ready for trial. I'm looking, we had a scheduling order, a new one that was entered a few weeks ago. And all discovery is due by early next week, July 1. And then Ms. Patel has a few weeks to file any motions other than motions in limine. And we even have a motions date where in theory we could hear motions in early August. Do you feel, Ms. Hodge, like you are on track to be able to get all that discovery to Ms. Patel by that deadline?
She is still missing some discovery, Your Honor, particularly the body-worn camera footage, which includes the victim's interview. I have made a request for that video. I don't have it yet, but I have been told that I should get it by the end of this week, which is today.
Yeah.
And so I just need to make a follow-up call to see if that's going to happen today or early next week to stay on track with the July 1st.
Got it.
Deadline.
But it sounds like what is missing would be something to which Ms. Patel is 100% entitled, but that's not going to give rise to a motion to suppress. I mean, it's body cam footage, and it would be the interview of the alleged victim as opposed to some police action of interacting with Mr. Farouk.
Correct, Your Honor.
Okay. Ms. Patel, beyond the body cam footage, are there things you know you're missing?
Not to my knowledge. I have a discovery packet and jail calls that were served to me, but I'm just not sure if there would be any medical records or other additional police reports. My understanding is there's no 911 call. I am missing, I think, the body camera of the defendant's arrest. I don't think he made any statements, but I do believe that that would be something that should be turned over in the event that the state plans to introduce anything from there.
Sure. No, it's you're entitled to that. If it's your client's interaction with law enforcement, you may want to use it, even if the state doesn't. So
right.
Is that part of what you're trying to track down, Ms. Hodge? Because you mentioned body cam, which could mean everything, but then you mentioned in particular the statement that the alleged victim, the complaining witness, gave to law enforcement.
Yes, Your Honor, I've requested all body cam footage. So
Okay.
I am not sure what that would show in terms of the defendant. I just know that it will show the victim's statement, but I have requested all body camera footage, and there are no medical records.
Okay. I remember this being the case, that Ms. Patel didn't have any, and you said, well, that's because we don't have any, and we don't think there are any. It's not that you haven't requested them, but your understanding, Ms. Hodge, is that there are not medical records.
Correct, Your Honor.
Okay. All right. So I am going to modify the bond. I will enter a new bond order, so you'll all get it. I need to get the old one back up on the screen here. There's a bird in the background. Do you hear that bird? Who has a bird in the background?
Not me. I did hear it though.
Maybe it's in here. It sounds like it's in the courtroom. It's very odd. So I'm going to modify the bond to a total of $50,000, and I will break it out as a bond in the amount of $20,000 on count 1, $20,000 on count 2, and $5,000 each on counts 3 and 4. That should add up to 50. It's still through the sheriff's 10% program. It will still, all the other conditions will be the same. The pretrial supervision level 3 and all those other things. I will leave the curfew in place and the no contact with Ms. Middleton and stay away from the incident location. I guess, Ms. Patel, it would be helpful to have an address that I can require Mr. Farouk to start at if and when he posts bond. That's not in this bond motion, this bond order, the old one, but I'll want it in the new one, because then pretrial services knows, at least initially, where they're going to find Mr. Farouk. So if you could get to Ms. Nelson what that address will be, then she'll get it into the bond order and I will sign that. And for now, Ms. Hodge, I'm going to leave the ankle monitor off, primarily because it's an expense. And we have Ms. Ortiz not working right now because she's caring for the daughter, and Mr. Farouk hopefully will be able to land on his feet and get working again. But until I get a sense that there is some stream of income and there's a reason to be concerned he's not complying with his curfew, I think we'll leave the ankle monitor out of the equation. But if anything is brought to your attention, Ms. Hodge, about non-compliance with pretrial supervision, let me know and we can revisit that.
Thank you, Your Honor.
Ms. Patel, do you have any questions about what I just described?
No, Your Honor, I'll be sure to get the information you requested to Ms. Nelson.
Okay. Ms. Hodge, anything else in the Farouk matter?
No, Your Honor.
Okay. So Ms. Ortiz, I am changing the bond a little bit. I'm going to let Ms. Patel talk with you and others, and then Ms. Patel will let me know what's the address where Mr. Farouk will be. His curfew is for night times, so that doesn't mean if he's ending up staying with his parents, he can't be at your residence. He just can't be there between 8 p.m. and 7 a.m. Okay?
Thank you, Your Honor. Thank you, Your Honor.
Before I let everyone go, I want to make sure I haven't missed anything. Ms. Crawford's on the phone. Ms. Crawford, Mr. Farouk doesn't have any open active probation or anything like that?
No, Judge, no open cases.
Okay, thank you. All right, that's what we're going to do. I appreciate everyone dialing in. Ms. Ortiz, again, I'm glad for you and your family that your daughter is doing better. It sounds like she's not out of the woods yet, but being out of the ICU is definitely an improvement. So good news with that.
Thank you.
All right,
Thank you.
thank you, folks.
Thank you,
Thank you,
Your Honor. And Your Honor, may I be excused?
Yes, ma'am. Have a good weekend.
Your Honor, that concludes my business as well. May I be excused?
Yep, take
Thank
care.
you. Have a great weekend.
me know, Mr. Forte, when you are ready to pivot to the other one. We'll get started with that. All right. All right. Mr. Warner's case. Let's get started with that. So this is case 20 SC 175773. It is State versus Warner. Mr. Warner is represented by Mr. Katz, who is on this call. Mr. Pinion is representing the state, and I see on the docket here that Mr. Katz on June 22nd filed a waiver of his client's presence for the bond hearing. So we will proceed with Mr. Warner appropriately in absentia. We can get him plugged in at the appropriate time, either in person, because we're starting to do those kinds of hearings here, or via Zoom when we next need to talk about things. Mr. Katz, I'll have you start letting me know why you think that Mr. Warner is an appropriate candidate for bond, given his charges and his situation.
I understand, Judge. I will tell the court that I am somewhat in the dark in this case because while he was indicted on about March 10th of this year, we filed, of course, entry of appearance discovery. Then I have not received any discovery. I know there's a very little bit about the case, although on or about January 13th of this year, we were going to have a prelim, but I waived that given the fact that I was given an extensive amount of time and had an extensive conversation with Detective Bender about the case. And we talked about it at that time. I think Mr. Pinion may have been there at that point or not. I'm not sure. This offense, of course, occurred on 11/26/2019. My client was arrested on or about December 14th, 2019. And he was indicted approximately 86 days after being in custody. And as I said, we filed motions on March 13th of this year. One of the things that I did get from Detective Bender, which I think is important in this case, is she seemed to indicate, and the court may or may not be aware, there was an arrest made of 2 individuals in Buckhead on around December 15th of last year. And at that time, it was on the news about 2 individuals who had been breaking into cars in Buckhead and so forth. And when they were arrested, they were found in possession of not only tools to commit crimes and to break into cars, but they were found in the possession of a weapon, which Bender at that time told me that they believed that was the weapon that was involved in the murder case, with Mr. Warner being charged at this time. And at that time, of course, Mr. Warner was already in custody. And I think the case may also show, I assume Mr. Pinion may also say that my client at the time of his arrest had, I think his family had actually sent him to Indiana, and then he was extradited back here. The reason he'd gone to Indiana is because on November 24th, 2 days before this shooting occurred, his house, for whatever reason, was shot up, and his family was assaulted. That's currently under investigation. I don't know what, if anything, has occurred as a result of that. So he was moved to Indiana, where he has other family, because of the fact that they were fearful for what was going on in the neighborhood. But our position is it had nothing to do with the alleged crime that was committed here. My client has been a resident of Atlanta, Georgia, all his life. He's 19 years of age. He has no children. He lives with his mother and has lived with his mother all his life. She currently resides, as the record shows, at 935 Washington Street, Southwest Atlanta, Georgia 30315. And again, not having a full picture of what's going on in terms of this case and background, to my understanding, his only prior is a theft case, or an automobile theft case, or a theft case from approximately 2017. I don't know if that's still pending or open or not. Certainly, I think the court will ask Ms. Crawford about that. But that's all he has. I don't believe he has any juvenile record or anything. If this case was a case that we've already extensively done what we can in terms of, with the lack of discovery, talked to various witnesses around the neighborhood and so forth. and also talked to his uncle, who at the time was with him about the time this was supposed to have occurred. He was actually somewhere else with his uncle and with some females at a B&B place around the corner from the incident. He was not there at the time of the incident. So obviously we'll have an alibi witness, or an alibi defense, which will be included in his case. And the court already knows, obviously, he's innocent to prove guilty or so forth. I don't know what, as I said, what evidence they have in regards to Mr. Warner being involved in this. There was questions about the reason why there was a shooting in the first place, whether it was a drug sale that had gone bad, whether it was exchange of money for a weapon, what the case may be. I understand the standard charges: murder, felony murder, aggravated assault, criminal damage to property, which I think was a shooting into the car that the victim was in, and possession of firearm to commission of a felony. It's our position that we were not there, we're not guilty. I don't think he has a prior record of FTAs, not likely to commit new offenses. We would also ask that he be placed on any kind of monitor or curfew. He has now been in custody since, as I said, December 14th of last year. And as the court knows, with the way things are with COVID and the Supreme Court, I don't have any idea when this case will come up to trial, if at all this year. In addition to not having discovery, I know we don't have a case management order as of yet. I think this today was also supposed to operate as a waiver of arraignment, which we're certainly doing. I think he initially had an arraignment, or I thought he was going to have an arraignment back in March or April. So this was to constitute his waiver as well. So we would ask that a reasonable bond be set, and we don't think he's likely to commit new offenses, not likely to intimidate witnesses. We don't know any of the individuals that were involved, or the victim himself. Having been retained for the case, we don't foresee there being a flight risk or a failure to appear for court, and we would certainly ask that a reasonable bond be set.
Okay, so a couple things, Mr. Katz, thank you for all that. One, if the outcome of today's hearing is a situation that does not result in your client's release,
Yes.
you should certainly feel free to re-petition once you get discovery. Part of our discussion today is going to be to hear from Mr. Pinion when he thinks you might be getting discovery. I appreciate your perspective, which is, I don't know a whole lot about the case other than what you've been able to learn from talking to your client's family. And it sounds like there's an alibi building from that side. So, if discovery contains further exculpatory information that you would want to bring to my attention, you should feel free to have us revisit this if you think that discovery materially changes the full discussion we've had today. We haven't completed it because I've just heard from you. Second thing, I do need you to file a waiver of arraignment form. Ms. Nelson can get you our standard form. If in fact, Mr. Warner is agreeing to waive arraignment, that will trigger a scheduling order. We can't do the scheduling order until your client's been arraigned. And he was indicted right about on the eve of things shutting down. So we haven't been able to do much with his case at all. In fact, the activity post-COVID is you filing your motion for bond and you waiving his presence, and that's it. So I'd like to change that and show more activity. So if you'll coordinate with Ms. Nelson after we're done, she'll get you the waiver of arraignment form. If you're comfortable filing that, please do so. And then we'll get a scheduling order. That will be the dictate to Mr. Pinion to provide the discovery. I have found that he doesn't need those, and he'll be more than happy to let us know when you can get discovery, but we haven't had that arraignment yet.
Well, the only thing I'll say, Judge, the waiver of our client's presence for the bond hearing today that I signed and formally filed does in the body of it say that we had waived arraignment and pursuant to 17793. So
look at that. What a great form. I forgot about that. As the designer of the form, we tried to cut down. So please disregard my second point. Pay attention to the first one, that we can revisit bond if we need to. But now that you filed that, and it was only 4 days ago,
Yes, sir.
then after we're done today, Ms. Nelson and I will talk about scheduling deadlines, and she'll get a scheduling order out, and that will help the case move along. I'll let you know, Mr. Katz, that we are slowly reopening for business, not for jury trials. So your point's well taken that a trial is in the distant future, but in the not distant future, we will be able to conduct in court with your client present things such as a suppression hearing, if this is a case that would have something like that. So we're not completely stalled, and my hope is that we can get this case ready for trial if that's how it needs to be resolved in the near term. And then we wait patiently along with others for getting jurors back here.
Yes, sir.
So no need to waive arraignment. You've done it. We'll get the scheduling order out.
Okay.
Mr. Pinion,
Yes, Your Honor.
tell me about the state's view.
Yes, Your Honor. The state is opposed to bond, and the victim's mother is watching by YouTube, and she has given our victim assistance representative a letter that she would like to be read. I looked over it. I don't think it's inappropriate. We could do that now or after I tell you about the case and why we oppose bond.
Please, you go first. Let me know why you oppose bond.
Yes, Your Honor. The state opposes because we believe that the defendant is a risk of further felonies, and he is a risk to community in that regard, and is a risk of flight. I don't know about Indiana, but I do know that shortly after this, he was extradited and found first by the fugitive squad in Nebraska. Also, the case that he had in 2017 before this, he was found driving a car that had been reported stolen, and the police started blue lighted it, and he fled. During that pursuit, he crashed and then jumped from the car. He was found to be wearing gloves in that stolen car. So that we think that is also a sign of risk of flight. Oddly, the officer thought that theft by receiving a stolen automobile, it appears as a misdemeanor. He wrote that on the ticket, so it looked like he sent it to state court with with fleeing and eluding and other charges, obstruction. When I looked at Odyssey, I had not seen that before. I did look at his record as a juvenile. It did show that he moved about 2.5 years ago to Washington Road, the address the defense gave. He did have a burglary adjudication as a juvenile. And he's also a documented gang member of the Bloods, the subsect YSL, and a kind of a new hybrid one called BN5. And in his jail cell was found a number of writings that I looked at actually, and that we will have ready in the discovery package, which talks about sliding, which stealing cars, and shooting, and it has the BN5 and blood symbols in that, helping indicate his membership in a gang. Your Honor, on the night that this occurred, the defense did say that the defendant was at an Air Bud rental, which is true. Him and some other gang members had rented this place. They're too young. The defendant was the only one that was not a juvenile. So I think it was either uncle or aunt had rented this place for them. They thankfully took some social media posts, and this is shortly before the murder, and they are showing guns and waving guns at the camera. And this is only about a block from the murder scene. So shortly before, and these are guns of the caliber. Now the defense mentioned that someone was arrested with a potential murder weapon. That is true. that is one of the individuals that the defendant is seeing. He has a gun, and this individual has a gun, and another individual has a gun in these social media posts. The unfortunate thing for the defense is that there were 3 guns fired at the victim. There are 3 different shell casings. So that, and the person that the defendant is seen with waving a gun at that Airbnb shortly before the murder is one of the individuals that was found with one of the weapons. And we are working on that individual's cell phone records and such to additionally look into it to possibly indict him on this murder as well. That individual is a juvenile. In fact, as I mentioned, the defendant was the only one that was an adult pictured in those videos of throwing gang signs and with these weapons. So we know when you arrest a juvenile, it starts the clock ticking so fast. We want to make sure that we have everything in order before we move on any of the juveniles. You're asked to then what led up to the murder. The defendant did give a statement that he was going to do a gun transaction with the victim. We do have the defendant's phone, and it does show that there was going to be he was talking with the victim about the sale of a gun. The victim was trying to buy a gun. We have 3 individuals, well, 2 now surviving, that were with the victim, and the victim had told him they were going to meet Squirrel. And the defendant acknowledges to police he's known as Squirrel. He goes by that on his jail calls. That's the name he gives as Squirrel. He is the only Squirrel that we know of. And in the victim's phone was GPS, where he was going to the location very close to where the defendant was at this Airbnb. The defendant told the police what looks like to be an untruth, that he called off the gun deal earlier in the day. But we have found from the victim's phone and from the defendant's phone that no, they were communicating about where they were going to meet for this gun deal up until the close in time to the murder. The victim was killed in a car, and the other individuals in the car said that the victim was giving money over to buy a gun, and that after the victim had handed over the money for the gun, instead of handing over the gun, the perpetrator shot and started shooting at the car along with the 2 people with the actual murderer started shooting at the car as well. The victim and the other people in the car fled, and the car does have bullet holes in it. Shell casings were found right there from 3 different guns. There was one individual in the car that went to middle school and high school with the defendant. The defendant had been removed from regular high school to Krim Alternative School, and that's where he knew the victim from, was from Krim Alternative High School. And the person that knew the defendant in the vehicle from middle school and high school identified him as Squirrel and picked the defendant out as a lineup. So we do have a lot of evidence against the defendant. He has a history of flight, and we believe that with the gang activity, and that he is a risk of further felonies. And then I believe that I covered everything that the defense mentioned. And at this time, if my victim assistance person would be able to read the victim's letter, they are the mother of the victim who is watching by YouTube.
Sure. We'll do that in just a moment.
Okay.
Mr. Pinion, it sounds like you have spent a fair amount of time reviewing the case file that your office has been able to accumulate. How soon do you think you can transmit what you have to Mr. Katz?
The paper discovery I can do quickly. We'll have to figure a way out to download it, the social media, the cell phone evidence. And that's a little more difficult. I usually rely on our paralegals who are not back at work yet to do that. But I can figure a way out to get that done. It would then just be like a flash drive that we would have
Okay.
at the front desk.
All right. Well, please do coordinate with Mr. Katz on how to get that to him. Ms. Rolak, if you would please share with me the information from Mr. Bryant's mother.
Good afternoon, Judge. Dear Judge McBurney, I am Sharice Bryant, Sherese Bryant, the mother of Braxton Bryant, Braxton. On November 26, 2019, my life changed forever because of the man who stands accused in front of you, Damon Warner. Words can't even explain how my heart feels right now. I feel that it would be unfair and unjust for Damon Warner to get a bond. Damon Warner took my son Braxton Bryant's life for nothing. To my understanding, he took an innocent life. I cannot visualize any reason why Damon Warner would shoot in the car and take my son's life. My son was only 19 years old. He never got the chance to have kids or simply to get to live a fruitful life because this was ridiculously taken away from him. So I plead with you today, Judge, with a heavy heart and tears in my eyes, please do not give Damon Warner a bond. If it was so easy for him to take my son, Braxton Bryant's life, what would stop him from causing this pain to another mother or family? Thank you for hearing me out. Sharice Bryant.
Thank you, Ms. Bryant, for sharing that. Thank you, Ms. Rolak, for relaying Ms. Bryant's pain and her concerns. It's obviously a difficult situation for her and her family, and I appreciate her sharing that. So, Mr. Katz, as the movement, I want to give you a chance to have the final word. I appreciate, like me, you're operating from an information deficit, and you may have heard for the first time today a whole bunch about the case, or at least heard it from the state for the first time. And I don't expect you to be in a position to say, well, here's the answer to this or that. And of course, as you pointed out initially, your client is presumed innocent. But I do need to weigh a variety of factors in assessing what is the appropriate situation for now for Mr. Warner as his case moves forward.
Well, Judge, I appreciate that. He's never been, as far as I know, indicted or charged, and certainly not in this case with any gang-related activity. He's not charged with a street gang under the Street Gang Act or anything. I think there's some questions about whether he is or is not a part of any gang. Without that being said, and it also seems to be based on what the state has said, and it was my understanding there were, in fact, maybe as many as 2 or 3 people involved in what happened to Mr. Bryant. And at this point, we may not even know who actually killed Mr. Bryant, and there may be questions about that. There actually were, in fact, 3 guns involved. I guess I'm a little baffled by this having occurred back in November of last year. That I don't know if Mr. Pinion knows whether the ballistic tests are back or so forth, or in any way know that the gun that was found on the individual that was arrested in Buckhead, who actually was in fact one of the guns used or shot at Mr. Bryant when he was killed, because I think that's an important thing. Nothing was found on Mr. Warner. I do want to correct something. I think Mr. Pinion is correct. He was sent actually to relatives in Nebraska. It was not Indiana. That was not a flight risk. That was as a result of his house being shot up 2 days before, and which was under investigation, and they got him out of town for purposes of making sure that he wasn't harmed and the family wasn't harmed. As far as I think the 2017 case, I guess based on what Mr. Pinion has said, it appears that the 2017 case was handled as a misdemeanor, and that's all he has on his record. And of course, I don't know anything about the burglary case when he was a juvenile and adjudicated. I don't know. I guess he was adjudicated guilty there. I don't know when that was. When he was 19, and I would just ask that a reasonable bond be set with certain conditions.
Okay. Ms. Crawford, do you have any adult criminal history for Mr. Warner?
No, Judge, nothing from Mr. Warner on the adult side. I pull up nothing for his record.
Okay, so he may well have the misdemeanors we heard about, but no Georgia felonies where
That is
probation
correct.
was part of this.
That's correct.
Okay. All right, thank you. So for now, I'm going to maintain the status quo. A couple things will be changing in short order. We'll get the scheduling order out, and Mr. Pinion will begin to make available to you, Mr. Katz, the discovery. There were several things that Mr. Pinion shared with me that make me concerned about the wisdom of having Mr. Warner in a non-custodial status while we work out these charges, these allegations against him. And so I hope you pay particular attention to the social media, the information provided by one of the surviving witnesses who identifies your client as one of the three. And I hear you that it may never be clear to the ultimate fact finder who fired the fatal shot, but you know very well that won't end particularly well for your client if felony murder is in the mix.
Yes, sir.
So
I got to work with what I got, Judge.
exactly, you do, and you're a realist, and I appreciate that. I wouldn't spend a lot of time right now if you're thinking about, well, I want to get back in front of the judge on bond with the gang stuff. Maybe Mr. Warner's wrapped up in that. Maybe he's not. Maybe it's music. Maybe it's not. Maybe it's just what these guys who are friends call themselves. That's not, to me, particularly persuasive at this juncture in terms of setting a bond. But several of the other things that Mr. Pinion shared are, and I've just flagged them. It does sound like what you were describing as an alibi, which is what it was described to you as, Mr. Katz, may prove to be something that you want to de-emphasize at trial if this is where the case ends up, depending on who was at the Airbnb and what the social media shows and what the evidence shows about who else might have been with your client if in fact he was engaging in the gun sale to Mr. Bryant. But those things to me combine to suggest that at this point, there's not a set of conditions that I could impose that would ensure that Mr. Warner stays in Georgia and not in Nebraska. But more importantly, that he would stay out of trouble while he's out. He would be returning to the same address with, I'm sure, a caring and loving mother, but who may find that she's got a young man that she doesn't have the same control over that she did when he was 12 or 6. Mr. Warner's an adult and he's moving in the circles he chooses to move in. And right now, those circles seem to have gotten him into a bit of a legal pickle. So for now, I'm going to deny bond. We'll keep Mr. Warner in a no bond status. But at least 2 things I can think of should get us back together in the near term. One would be if we're just not making any progress on the case, Mr. Katz, meaning COVID has made it so that we cannot have hearings if there are motions we need to work through. And 2 would be if you're not getting the discovery that Mr. Pinion has described that he has. And I know you're not going to get it tomorrow, it's Saturday, but Mr. Pinion does need to jump through some hoops to get the electronic information to you, because I know they are operating with low staffing levels in the DA's office. Not Mr. Warner's problem, but it does mean that I'll be a little more flexible in allowing the DA's office a bit more time in terms of pulling things together. And you and Mr. Pinion can talk, Mr. Katz, about whether you're comfortable getting things in dribs and drabs, because he may be able to zap you the paper discovery this weekend. And it may take a little while to get jail calls or the social media or the cell phone dumps. But you two can work that out. All I'd ask of you, Mr. Katz, is that if Mr. Pinion is not meeting the deadlines or agreements that you two have, let us know. And that may be a reason for us to revisit the question of bond.
Yes.
And the third one would be you look at the discovery and you think it represents something very, very different from what Mr. Pinion relayed. And that may cast a different light on the factors that concern me the most. So that's where I am now. Mr. Pinion, anything else on Mr. Warner's case?
No, Your Honor.
All right, Mr. Katz, anything else?
No, Judge, I'll just, let Mr. Pinion get what he can get to me, when he can get it to me, and we'll just go from there. Take it one
Okay.
step at a time.
Great. Well, we'll get the scheduling order out and that'll set the maximum deadline for stuff. But it sounds like Mr. Pinion is amenable to starting to push things in your direction sooner rather than later.
That's fine, Judge.
All right. Thank you, everyone. Have a good weekend.
Thank you.
You do the same, Judge. Thank you.
Bye.
Thank you, Your Honor.
Bye, Judge.
Bye.